we now have the detail with respect to what you can actually do as an employer. So the first thing that the Act does is it makes it really clear that you can't change the hourly rate of the employee. So you can stand down an employee, so by either reducing their hours or totally not having them come to work. And you can only do that in certain circumstances. That's when you can't usefully employ them for their normal hours that they would work. So if you could employ them, then the provisions of the legislation won't apply. So not only do you have to be eligible, but you have to be able to establish you can't usefully employ that person. And that not being able to usefully employ them is because of COVID-19. So you also have to show that your direction is safe that you're making. And basically, we now know how the payment's going to work. So if you require somebody to work and you've just reduced their hours, say, to 15 hours a week, then you will have to pay them either the $1,500 or if the amount that they would ordinarily earn based on their hourly rate was greater, then you must pay that rate. So the rate of pay is pretty much guaranteed under the legislation. You can also change the duties, which is really important because we need some flexibility under our present Fair Work Act and our awards. You can't just go and employ someone to do X and then just say to them, well, I'm sorry, you've got to do Y. So we've got some now ability and flexibility to say to someone that during that period of this code of COVID-19 stand down, we're going to ask you to do different things. And so it has to be within the employee's skill and competency. The employee has to be qualified to do that job. It has to be safe to do it. And obviously, that is what was occurring naturally by agreement with people anyway, so that if there was something within a business that no longer could be done, for example, being a waitress and serving people at the restaurant didn't work, but you might have gone to take away part and you may have actually had to help do some preparation of meals or some cleaning of dishes and things like that. Well, that was a little bit difficult prior to being able to be told that as long as it's safe, as long as it's within their expertise and competence, as long as it's what your business does, then you can make that direction. And we can also now be clear that we can make a direction as to where that work can be carried out. So provided that you're eligible for the JobKeeper again, the employee has to be eligible, you can make a direction as to where the work's to be done. You can't make anyone travel unreasonable distances from their home, and it has to obviously be safe and it has to be within the scope of the employer's business. And we can change the days of work, so we can change how the hours are made up and how the days are on different dates and different times. Again, it's got to be reasonable. All the way through the legislation is this concept of your direction has to be reasonable, and will have no effect if it isn't reasonable. You can also look at paying people annual leave, but you must leave them with, give a direction that they have to go on annual leave, but must leave them with 2 weeks. And the employee has to consider the request, and they've got to be reasonable if they decide not to accept it. The only other thing that perhaps people may not be aware of is there's quite strict consultation rules. So you do have to, as an employer, give the employee written notice that you're intending to give them a direction. And you do that by either 3 days before you're going to do the direction, you give them written notice, you're going to bring on the direction. Or if the employee says, look, I don't need this notice, and they generally agree to you not having given them the notice that you're going to do something, and you've consulted, that will be fine. At this stage, we just know that direction, either to stand down, change hours, change duties, change location, must be in writing, but there is provision for the prescribed form to come out. So we know that if you stand someone down, I think this is really important for employers to remember now, it's very clear that the employee's leave entitlements will accrue as if they haven't been stood down. So they'll have continuity of service through that whole period, but they will also have it based on their full rate of pay that they would have for their ordinary hours that they used to work. So that's just something to keep in mind. The employee can, during this period, it'll be interesting to see if anyone does, they can request that they are involved in some secondary employment. So, I need to go and work for another takeaway, or I need to go and work for another organisation. And you can't reasonably refuse that request as an employer. They can ask for training, and they can also ask for professional development. The Fair Work Act is still, the Fair Work Commission is still going to be able to deal with disputes. So if someone feels as if the direction's not reasonable, or perhaps it's not safe, or it's not, there's a breach of the other sections of the legislation, you can come along and have a conference with Fair Work to try and sort it out. So it's not a free-for-all, and just all the laws with respect to unfair dismissal, discrimination, general protection, they're still going to apply. You're going to have to consult, you're going to have to do this in a way which is fair. Probably the biggest challenge for people is working out how many hours, if they are going to have their employees work, they're going to have the work. Are you going to work up to the equivalent of the 1,500 on that person's hourly rate, or what are you going to do?
I guess as well, I'll touch on that, and then we'll come back to a few other the concepts. I guess if you're getting them to work 10, 15 hours, the minute you get them to work, even if it's up to the 1,500, and correct me if I'm wrong, then superannuation is payable on that. Whereas if they're not working at all and getting just JobKeeper, superannuation will be payable on that. Is the legislation talk to that at all?
The legislation doesn't talk well to the super, but we know that it's not income if you're just getting the $1,500. So you won't be paying super as an employer on the $1,500, but anything you pay over and above the $1,500, will be subject to super. But I think it's more if people are doing their cash flow, it's if you're not working at all and you've just stood down the person, it's easy. You're going to claim the $1,500, you're going to pay it. But if you are deciding, well, look, we want to look at standing down an employee and reducing their hours, we want them to do some work, then you just have to work out what is how much more you have to pay them, either the actual amount they would have earned under their previous hourly rate, or if it's the 1,500 is greater, then you have to pay the 1,500.
Yeah, okay, that's very good. And I guess too, that by the sounds of the legislation, very much the concept of fair and reasonable. So I guess any changes you're looking to make, or even bringing back employees, key thing is to consult and agree on what it will look like. Yeah,
that's right. I mean, the consultation really should be a written notice. I'm going to make this direction, ideally, and that the agreement and the direction that you give has to be in writing. You have to give the direction to either change the hours, change the days, change the location, or change the work in writing.
Yeah. And Michelle, what if someone's been stood down and now JobKeeper's eligible to be claimed, but the employee still wants to be on stand down? Can that? What are the options there? I guess
Well, there's sort of the obligations with respect to, an employee not refusing the request. It has to be reasonable as well. So if the employee has already been stood down and you're going to give notice and say, hey, look, I'm eligible for JobKeeper, I'd like you to come and work for 10 hours a day doing X or Y, then you're going to have to give that notice. That's the direction you have. You're going to have to consult, and the employee won't be able to unreasonably refuse to attend to work.
All right, we're getting
you can go to Fair Work and have a blue over what's reasonable and what's not.
And your recommendation on this at this point in time would be to try and avoid that, no doubt.
Well, I think it's an added stress and an added expense that people don't want and don't need.
Yeah. Michelle, there's some questions coming through, so I might we'll go to them. If we have a casual employee that works no more than 4 hours per month, do I have to offer them JobKeeper?
So if they were eligible on the 1st of March, and so they'd been regular and systematic for 12 months, and you're losing the required turnover, and you intending to claim JobKeeper, then you will have to, you will be claiming, you can't pick and choose, which employees you have the JobKeeper for. So if they're eligible and you're applying as an entity, then that person you will apply for. And there doesn't seem to be, which I think we all thought there wouldn't be, any provision to say to someone, well, actually, you used to only do 4 hours, and now I'm paying you the equivalent of X number of hours. There doesn't seem to be any provision to get people to work up to the 1,500.
Right.
It seems to be a bonus for the casual.
Right. And I guess the next question was along similar lines. If you've got permanent and casual employees, do you have to give them all JobKeeper, as in one in, all in, but I guess that's what you're saying. If you any employee, whether permanent, part-time or casual, that was eligible as at the 1st of March, if you apply as an entity, you pay all of those people on the list. Is that right?
Yeah, look, we don't set, you're applying for JobKeeper and you're going to have done something with those people. So if they were employed, if they were employed as at the 1st of March, or you've stood them down or terminated. So if you terminate them because of coronavirus, and you have to reinstate them.
Yep.
To get JobKeeper for them. So so they're going to have to be. You're going to either have to reinstate those people you've terminated,
yep,
or they're going to have to be employed, and then you're going to say, well, look, these are the people who are eligible at the time, and then you're going to have to work out, well, what do I do with respect to how those employees are going to work?
Sure. Yep. Okay. And another question: if an employee has requested to stand down because they feel unsafe and have requested 2 weeks annual leave, do they get JobKeeper as well for those dates?
No, but you can direct someone to take the annual leave. So I don't.
Yep.
Yeah. So if you direct someone, I'll just have a quick look at that then. Yeah, I think they will only get their annual leave and the JobKeeper. Yeah. Yeah.
And I guess there's so many different specifics out there. I guess the advice for today is make sure if it's a little bit out of the ordinary, you get the right advice to do the right thing, because all the legislation, the Fair Work Act, it's still in place, and you don't want to have an action brought against you because you've done inadvertently the wrong thing.
Yeah, exactly. That's right. And you're going to, we have got the provision under, like 99 awards have been amended so that people can have 2 weeks unpaid leave if they are directed to self-isolate and they're not sick, and you can agree to that longer. So people can have, under the awards, coronavirus leave now, unpaid 2 weeks.
So if businesses have stood down employees, and now this legislation has been passed as of last Wednesday night, what should they be broadly doing right now if they're thinking of reinstating those employees and they haven't been in touch, with them?
Well, if they're going to look, so they obviously have to get in touch with them. They need to explain to them what they are intending to do. So if you're going to say, well, I will be continuing to stand you down, I can't usefully engage you, I will be claiming the JobKeeper, and that will be meaning that the employer will be entitled to the $1,500. If you're an employer who's thinking, well, I need now, you've been able to adjust, you might have thought of different businesses or different things that you can do within your business you hadn't thought of beforehand. Well, look, actually, I could get people in to come and do some policies and procedures. I could get some people to do some maintenance or painting. This person's got these skills, it'd be quite reasonable for me to do all of this. Then you will have to start consulting. So you'll have to give the notice that you're intending to give a direction that they come back and say you want.
Hello.
Yeah, sorry.
That's okay.
So you're going to start consulting. You're going to start talking to. You're going to give the direction at least 3 days before. You're going to start talking to the person about what it is that you want them to do, and if you're going to get them to do different hours, different jobs, different location, then it would really be wise to have a look at what are the criteria that says I can do that. It has to be within their expertise, it has to be safe. It has to be something that we do. So you're going to have to plan what it is that you think you can do and use these employees for. Make sure that you're satisfied that you fit within the Fair Work Act and you're allowed to give that direction. Once you've satisfied yourself you can give that direction, then you can start talking to the employee about how you can return them to work.
Great. And of course, all of that, most importantly, document it, get it in writing, and get it signed off and agreed by both parties. Yeah.
Well, you have to give, the direction has to be in writing, because the benefit of the legislation is previously we were all relying on, well, I'm going to only be able, I can't force you to change your duties, I can't force you to change ours, we're going to have to agree. This one here is more about you do a consultation process, but you'll actually be able to give a direction. So there's a little bit different. You've got a little bit more power if you're being reasonable and you satisfy all the sections. And then if that direction isn't followed, then you can come along and look at the dispute resolution sections and say, well, we might have to go up to the Fair Work Commission and have someone help resolve what's reasonable and whether they should be doing what I'm asking them to do.
Oh, okay. So I guess that's a really big point, a really big difference. And I guess, was that a key amendment coming out of is it an amendment to the Fair Work Act for that 6-month period, or is it?
It's an amendment to the Fair Work Act. So, generally speaking, most of the changes that the Act is allowing us to do now could really only be done by agreement. So now you've got some qualifying factors, and if you fit into those qualifying factors and you follow a process, you can actually give a written direction.
Right.
So it's not so much now about, but consultation is an important part of the legislation. But ultimately, as long as you can say you've talked about it, you've tried to resolve it, at the end of the day, you can actually give a direction under this new Act to say, well, I want you to come, and I think it's reasonable 10 hours a week, or, change your day to Tuesday and Thursday, or whatever it is. Yeah.
Okay, that's great. I think that's really important to note. Michelle, anything else that we haven't covered off that you think that was particularly useful? I know we've covered a fair bit of ground.
No, I don't think so. I think it is just important to remember that though you have the ability to give directions, you're going to have to be mindful, really probably mostly the discrimination section. So whether or not it's reasonable for the direction you're given is going to have an impact on that person's personal circumstances. So if they're a carer, if they have small children at home, all of those factors are going to come into that. A lot of those, discriminatory reasons are going to come into whether it's reasonable what you're asking that person to do. And it might be at the end of the day that they would like to have someone return for a period of time. It may not be reasonable, and you may have to leave them stood down and just give them the $1,500 and have no work in return.
Very good point. Very good point. Thanks very much, Michelle. We'll come back to you in case there's any more questions towards the end of the webinar. But as always, thank you for your time. I'll bring in Paul Radford now from Connolly Suthers Lawyers. Hello, Paul. Hello. Yeah, there you go. Hello, okay. Paul. How are you?
Very well, thanks.
That's the way. I guess first and foremost, thanks for your time. I guess the key thing here is the federal government's, they recently made an announcement on the code of conduct for commercial tenants and landlords. I guess the big point is it's not law at the moment, but the federal government has released this code of conduct. Can you tell us a little bit about it?
Sure. Well, it's consistent with the federal government's hibernation strategy. They want to put everything on hold until we all come out of this mess. It's a sort of guideline for how people, landlords and tenants, should try and negotiate an outcome. Some of the key features in it are landlords aren't allowed to terminate a lease during the period, which is the same period for now as the JobKeeper. There's waivers and deferral of rent between 50% and 100% of rent. There's provisions for amortisation. Basically, it's a method or guidelines for people to be able to, or be able to help them reach agreement. There's some interesting things in it, like landlords should seek to share any benefit they've got from deferral of their own loan repayments. How anyone could ever determine that, I don't know. A lot of question marks. It's not law yet. Each it's just, I guess, a motherhood statement from the National Cabinet that they want the states to pass these laws. Now, I checked before I came down here today. Queensland hasn't done anything yet. I don't think the other states have. It's quite a lot of work to get that into law in Queensland and in any state. I think there's some misapprehension about eligibility. You're eligible if you can show your business is severely affected. A way to do that is showing that you've got JobKeeper eligibility. But I don't know if anyone's eligible yet. So there's room for landlords and tenants to argue whether they're eligible or not and whether the scheme applies. So if it doesn't apply and you say, I'm still eligible, who determines that?
Yeah.
And And none of those questions can be answered until we see some legislation.
Yeah. I guess while we wait for that legislation to be passed, is it fair to say that old comment of acting in good faith, what are you seeing at the moment between landlords and tenants? Because I would imagine that there may be both sides that may be, taking advantage of this.
There's a small minority that are. Most people get on with it, reach agreement, are honest with each other, aren't trying to take advantage of the situation. But, it's not a perfect world, and some people are taking advantage of the situation. I've got people ring me up and go, tenants ring up and go, I've got no customers walking in the door, I can't pay the rent. And the landlord rings up on a different building or whatever. The tenant's not paying me rent, what do I do? And they've everyone's in the same situation. The problems for tenants, everyone's in the same boat. There's a concept in law or words that are floated around, force majeure, which is a French civil law concept about if something happens, a contract will have a provision saying there's force majeure. If there's some event behind everyone's control that comes in and all bets are off, there's a waiver, there's an abatement or a suspension of obligations or the ability to terminate. That would be nice if your lease said force majeure, this applies, but in Queensland, I don't know any leases that have that provision in them. I've never seen it, which then leads you to common law and something called the doctrine of frustration, which is a similar concept. Something comes along out of everyone's contemplation and doesn't allow a contract to be performed. So you could argue that here, but in a nutshell, I don't think that's possible. When SARS hit the world or hit Asia in 2003-04, there were similar orders in Hong Kong about people not being able to trade or go outside or whatever. And a tenant on a long-term lease had a 10-day stay inside order, and he applied to the court to terminate his lease based on frustration and lost, because fundamentally 10 days out of a lease for years wasn't sufficient. So that's the problem for tenants. You've still got to pay the rent, you're still obliged to, but you just can't. So that's why the federal government said, look, let's be real, here's what we want you all to do. Not law yet. Even when it becomes law, you've still got to agree. And if you can't agree, there's a compulsory mediation process. For retail tenants in Queensland, there's nothing in the Retail Shop Leases Act that helps. There are provisions there that allow for or imply terms of compensation where landlords do things to tenants, like start constructing a new part of the shopping centre and then access is restricted. There's provisions in there, but this isn't something a landlord's willingly doing. This is something that's beyond their control. I just don't think they apply. So from a legal point of view for tenants, the problem is there's no way out under the current circumstances. The problems for landlords, the tenant can't pay. What do? Sue them for the rent, terminate the lease and throw them out. That's all not going to happen in the short term because it's hard to get anything done in the courts. They're facing the same problems. And by the time you get a judgment and want to execute on it, the new national code might be law. So you could spend a lot of money trying to exercise or protect your rights under a lease, but then it'd be taken away from you because the new laws come in. The other thing is insolvency laws, which have been passed because they're federal laws, effectively stop people bankrupting someone or putting a company into liquidation for at least 6 months. There's extended periods and there's a minimum $20,000 amount. So you might sue a tenant, get a judgment, and then not be able to do anything about it for 6 months. And so there's no quick answer to the problem. what the federal government wants you to do is reach agreement, and that's why they've released the code. I think the simple answer to most questions are ignore everything you've read or heard, try and reach an agreement. Here's a good roadmap to doing it. These are the types of things you should be doing. But if you can't reach agreement, if a landlord and a tenant can't reach agreement, get yourself a mediator and just jump through all the processes to get to the point where you'll end up anyway at some point.
Yep. Sorry, Paul. So is that I guess the code is really driving at saying landlord, tenant, try and work together, be open up front, and try and reach an agreement for this short term. Can the agreement be for only a short term, or is it does it then, if an agreement's reached, does it effectively void the previous lease, or is that still unknown at this point in time?
Look, it's the law. There's no law. It's really people who can reach an agreement in whatever terms they like. And you would expect, like people that have called me, I've just said, look, halve the rent for 6 months and then see where you are at the end. And it's a temporary thing.
Yep.
And I just say that as a suggestion, go away and sort it out. It's your lease. Talk to your landlord, and most do. But the code's talking about a minimum 50%.
Yeah.
And some people just can't agree. So it's like get a mediator or get together and try and nut it out. And so to answer your question, it can be temporary, it can be forever. It depends. Lease terms might be about to expire. I've noticed some businesses here that have shut down. But I think because apart from the pandemic, the leases have just expired. So it's such an uncertain time. Well, why would you continue on? So there's so many different scenarios.
Yeah.
The message is get together in a room and sort it out. It's not suing you or taking some court process to get you out. It's not going to help you. The government want people in their businesses when this is all over. They don't want people kicked out. They want to be able to get it going again. Because just the cost to start a business again, like from scratch, it's phenomenal. And that's what the code's designed to do. So really, it's a roadmap. It's sort of a checklist of things you should follow to help you reach an agreement.
Yeah, that's a very good. I guess the concept too is similar to the JobKeeper of that fair and reasonable. I guess isn't it that both parties work together? They
have to. Like, you just be honest. Let's say, look, this is my true. Like, these are my takings. I just can't pay. I'm not hiding anything. And landlords, under the code, landlords are supposed to offer up what they've received in deferrals from their bank. I can't imagine many landlords opening up their books to show what they've received and passing it on. I just don't know. But be real. And I think if you go to a landlord goes to their tenant and say, look, we've reached this deal, then goes to the bank, this is the deal we've reached, try and work something out with them as well. But it's about talking and not ignoring it and just trying to resolve it as soon as possible so you can get on with something else. There are many other things to worry about and fight about at this time.
We've got a question coming in. At the moment, and I guess because it's not law, it's hard to determine, do tenants have to prove to the landlord via evidence that their takings have either ceased or decreased significantly?
I'm just going to go to another terminal.
No worries at all. Just stand by because we do have a couple of questions coming in, and we'll just hold for a second until Paul gets onto another computer. The question was about whether tenants have to prove anything to their landlords in relation to a reduction in turnover or a nil turnover. So
this nice. Technically, no.
Yeah.
But if you want someone to agree to something, you'd be wanting to show them something so they can say, yeah, that's fair enough. But if you say, I don't know, if you're a business that's been shut down and cannot trade at all, like a pub or a dentist or something like that, it's obvious that there's no income at all.
Yep.
But others are still maintaining part of the business. It's landlords entitled to have something to hang their hat on to show it's legit. I've seen some forms floating around to given to tenants to fill out with all their financial data, and like to give to a landlord. There's no requirement to do that. Under the code, you have to show you're in distress. Where who determines that, I don't know. It's not the landlord ultimately, but anyway, to reach an agreement, you need to show something. So I think be fair, be honest, be open.
Yeah,
and you're more likely to get an agreement.
Yeah. What about under the existing terms of the lease? Notice to end or move out of the property. Any changes there, or no? The lease agreement still stands.
The lease it's the same now until the new laws come in.
Yep.
Which stop you being evicted. So if you haven't paid the rent, the landlord's entitled to give a notice to remedy default. If you don't, normally 14 days is allowed, and if you don't remedy it, i.e. pay the rent, they can terminate the lease, kick you out. They can't just change the locks. They need to get a court order to be able to take possession. So that all takes time, and it all takes money. So months to 6 weeks before that can happen. But yes, at the moment you can be kicked out. There's nothing to stop that happening right now.
Yep. Okay, and of course we won't get into residential leases, because that's a whole new kettle of fish. And I guess any time frame for when this legislation may or may not be passed by Queensland?
No idea. I've been looking and I can't find anything.
Yeah.
Anastasia Palaszczuk on the 8th made an announcement that the laws were coming.
Yep.
And that was it.
Okay.
Yeah.
And I guess with that, a bit of a message to people there is, don't wait for the laws, because they may come next week, they may come in 2 weeks, they may come in a month's time. But I guess the real impact, the real thing is do something now. If you're a tenant and are genuinely struggling to pay, speak to your landlord. And if you're a landlord and your tenants stop paying without discussion, have those discussions.
Get together. And look, it'll be resolved quicker face to face. Writing the letters. I've seen one say, we're paying 20%. That's it. That was the negotiation from the tenant, and that wasn't agreed to. And it's still going, and we'll see what happens. But if you're in that point where you just can't agree, get a mediator.
Yeah.
And sit down, and it might all be resolved in a morning.
Yeah, and get it done and done quickly.
Well, there's other things to do.
Yeah.
So talk to your bank then.
Yeah.
It goes on and on and on.
Yeah, I guess that's the thing. If a landlord has had to do that, then there, the government has given additional capital to banks to enable them to loan at low interest rates or to defer interest payments. So if you're a landlord that has been impacted by a tenant, I guess the advice is go and talk to your banks and see if you can reduce your cash flow on that front as well, because the Prime Minister has said a few times we're all in this together.
Exactly. Yeah. It's all about discussion.
Yeah, absolutely. All right, we've had a few questions. Paul, is there anything else that we haven't spoken about that is particularly pertinent at this point in time?
I don't think so. I'd just like to say one thing. There's a lot of stuff on the internet to read, and like the code, there's a lot of information about the code, but it's of no use at the moment. It's just a guide, and nothing's changed. You're still liable to pay the rent. But I mentioned the problems facing both parties. So agree to something.
Yeah, that's terrific advice, Paul. Thank you for that. We've already covered some questions. I guess, Michelle, any final thoughts or comments in relation to anything today in JobKeeper?
I can have a go at answering some of the questions that have been put through, if you like. Someone had asked whether or not a registered company with one director who's a sole operator and doesn't take a salary because it's not profitable is eligible. Yes, there will be provision to be eligible, and if you're paid otherwise, like if you're taking something but it's not with reference to an hourly rate, and you've got an award that applies, you can use the minimum award amount as your base rate. So there's provision in the amendment to say that you can use the base rate that's in an award if it applies to you if you're not getting paid on an hourly rate. And I'm not sure what the other question is asking, but if you're in a business and you're running it and you are a permanent employee, then the employer is going to be some other entity, and that entity can register. And even though you're running the business, it's a bit artificial, but all of the opportunities for the employer still exist, even though you're running it. It's just you can stand yourself down, and you'll be standing yourself down, reduce your own hours, but you can still pay.
Yeah, great. Terrific. All right, Michelle, thank you very much. And if there's any questions subsequently, we'll get them answered and put on the website. So thanks, Michelle.
Thank you.
Paul, just one last question for you, and I didn't touch on where there's a self-managed fund that owns a property and leases it to a related party. There are opportunities to reduce that rent without having penalties impacted on you. Is that right?
Yes, essentially, as long as they're temporary.
Yeah.
Have to be at arm's, and there's an arm's length requirement in the federal superannuation laws. The tax office have said they are not going to overly police this or insist on market evidence, because they actually know what's going on. It is real. It's just a matter of documenting it properly. Key is that it's temporary, and like if it's commercial, like what other non-related landlord and tenants are doing, it'll be fine.
Yeah, great.
But the key is just documenting it properly, i.e., deed of variation of lease, and that it's temporary.
Terrific. Thanks very much, Paul. I want to thank you both for joining us today, giving up your time for this. It's a bit of a minefield to navigate, and today you've been able to simplify it. So we very much appreciate your time. Michelle, we've just had a comment here that says, happy birthday, Michelle. So is that correct?
She's gone off there.
She's probably gone. Anyway, thanks very much for joining us, everyone, on our webinar today. They're going to be a weekly feature at Townsville Enterprise, so please join us again next week. If there's a topic or anything that you would like us covered, please send us an email, tel@tel.com.au, and we will have that topic covered for you with our panel of experts. So thanks again for joining us. I hope you are all staying safe and well in this really challenging environment. We'll see you soon. Thanks very much.
Thank you.
Thanks, Wayde. Thanks, Paul.
Thanks. Bye.